Welcome to the Global Operations Group Quick and Dirty 30 podcast, where we take 30 minutes to have conversations with entrepreneurs, investors, business and finance and legal specialists for information non-US based companies, foreign companies need to know if they're interested in entering the US market. My name is Alex Chiswick. I'm the CEO and founder of Global Operations Group. Today, I'd like to welcome Alex Garanin, Esquire, as our guest. Alec is a partner with Duane Morris, an international law firm with 23 offices in the United States, located in 14 different states, and offices in England, Singapore, Vietnam, Myanmar, and China. Alec's practice focuses on intellectual property matters, including patent, copyright, and trade secret litigation, unfair competition litigation, and intellectual property licensing. He regularly represents one of the world's largest enterprise software companies in patent, copyright, software licensing, and intellectual property disputes, both in the courtroom and at the negotiating table. He works with startups and established company clients on issues concerning proper data acquisition, data use, data ownership, and software and data licensing. Somehow, amongst all of that professional expertise, he found time to create and teach a trade secret law course at the Villanova University School of Law. He's consistently ranked as a top patent in intellectual property litigated in Pennsylvania by the Best Lawyers and Super Lawyers publication in America. Finally, and most importantly, I'm proud to call him my friend. Alex, welcome to the program and thank you for joining me.
Quite an introduction. Pleasure to be here.
All right, you deserve it. So we have 30 minutes to talk about all patents, trademark, copyrights, and trade secret information that we can fit into that time. So let's go ahead and jump right in, okay?
Of course.
Prior to the call, I know I've shared with you that the Global Operations Group, my company, has partnered with the American Chamber of Commerce in Ukraine to help Ukrainian companies who wish to enter the US market. Much of the information that we're going to discuss applies to any company from any foreign jurisdiction entering the US market, but if we can fit in and specify anything particular or specific to Ukraine, we'll do that when appropriate and if appropriate. So let's talk patents, trademarks, and copyrights for the next 30 minutes. So first question for you. And as I've told you before, this is a conversation. This is not a lecture, so we can keep it conversational. But let's talk about what foreign companies need to think about when they enter the US market. What's the first thing you typically talk to your clients about?
Sure. So I regularly represent, as you said in your introduction, overseas companies like SAP, a large software company, like Heidelberger Druckmaschinen from Germany, which does large format printing presses, medical device companies that have some of their partners overseas in Australia. And so oftentimes it's in litigation. Oftentimes it's in intellectual property acquisition. And the very first thing we start off with for all these clients is give them an understanding of one particular aspect of the US system, which is there's the federal level, the US government, Washington, DC, and then there's each of the individual 50 states. And depending on what kind of intellectual property you're seeking, which of primarily the four boxes that you mentioned, that you want to acquire, you may be dealing with agencies or organizations, either at the federal level or the state level. And I'm happy to go kind of break that down box by box if you'd like, but I may stop there because otherwise I'll take up the whole 30 minutes just lecturing.
Absolutely. So no, that's a great start. I'm glad that you mentioned the differences between various jurisdictions on federal and state level, because that's the first thing that I typically talk to companies who wish to enter the US market from overseas about, right? Most of the time companies enter from whether European country, Asian country, doesn't really matter. Most of the time they're looking at a single jurisdiction, right? Germany is Germany, France is France, Ukraine is Ukraine. Right. There may be some differences in, kind of their areas, or maybe some, you wouldn't call them states, but kind of different areas within the country for particular matters. But mostly it's a single uniform, either legal or tax scheme that works in that country. In the United States, we have the federal level. We have 50 some states. We have local jurisdictions, and it varies greatly. So I'm glad that you brought up the difference, because that's the first thing that the companies need to understand, is that it depends where they are, where they land here, what state they're in, and what level they want to play in terms of intellectual property protections. So let's expand on that in terms of unpacking let's start with the federal level, and then we'll kind of move to the state levels. what is it that they should be paying attention to or thinking before they enter the United States in terms of protecting their intellectual property?
Sure. Let me start with that by creating a hypothetical Ukrainian company in my mind. And I'm going to go in computer tech, for instance, software, telecom, something along those lines. That's a primary sector that I deal with, along with medical devices. And it's about half and half for each. But let's just stay with the Ukrainian telecom company. The first thing that you're going to, or a software company, or a computer game company, right? Maybe the next Witcher.
There's a lot of technology expertise coming out of
Yeah.
Ukraine, so it's a very relevant and specific example that I think will be useful.
So the first thing my overseas clients that are in that space talk about is patents, right? How do I get patent protection? The number one takeaway there, when you want patent protection, you are only dealing with the U.S. federal government. You can't get patent protection from any state. So there's a specific agency in the U.S., the United States Patent and Trademark Office, and they have a very particular process by which you apply for a patent and then ultimately receive patent protection. There is a whole panoply, a whole set of procedures and regulations around it. You would need to engage a patent lawyer really to navigate that for you. You can think of it as a multi-year conversation between your patent lawyer and then agents of the Patent and Trademark Office negotiating, and it is really a negotiation. It happens in writing, but it's a negotiation. Negotiating the exact words that are going to describe what you invented. So if you want to protect a particular computer program and an aspect of the algorithm or an aspect of the way in which it interacts with databases, at the end of the day, you're going to get that protection by writing up a description of your invention in very precise language, and then negotiating literally word by word that claim, and it's called a claim, with the U.S. government. And it's only the U.S. government that's going to give you that protection. That's in the patent space.
Right. Okay. So is this something that you would recommend to your clients coming into the United States they need to think about and take action on prior to actually starting to do business here in the country? Or is this something they can do after they establish operations here?
Oh, it's absolutely something you want to think about beforehand for a number of reasons. One is just competitively. You want to get that process in place and start building your fence around what you think is going to give you the competitive advantage. Second, particularly if you're raising financing or funding, and then this applies both US or overseas, one of the first questions that's going to be asked is, well, what is your moat? What is your barrier? What does your patent protection look like? It's true of software companies. It's definitely true if you're a medical device or a life sciences company, where the value of patents is even greater than in the software and telecom and IT space.
Right. Now, does it matter whether the company has patent protection or some other intellectual property protection in their home country?
For the U.S. market, it does to the, and this is going to get a little too, maybe a little too sophisticated, but it will matter from the perspective of whether you can benefit from the filing date of that overseas protection in order to establish that you invented something first by relying on the activities overseas and linking it up. And there's a very particular patent mechanism, patent cooperation treaty that navigates that. So yes, from that perspective, it's a factor.
Okay, so that's good. Let's unpack that particular part a little bit more specifically for Ukrainian companies, because Ukraine is part of the patent cooperation treaty that has been around since 1970, came into effect in 1978. It allows foreign companies or foreign individuals, really by foreign I mean anyone in the world, to if they are a resident of a country that is part of that treaty, to do a filing in what's kind of the international organization for protection of intellectual property. It doesn't mean they're going to get a patent. There is no patent internationally. The organization doesn't grant international patents. There's no such thing, but it establishes their kind of first stake in the ground that they had an idea, they've executed on that idea, they have something patentable, and then they have to pursue patents in individual countries that they wish to enter, such as the United States. And ultimately, it's the U.S. Patent and Trademark Office in U.S. that's responsible for granting U.S.-based patents, right?
Absolutely.
So, yeah. So That's what you're referring to. It's that's coming out of the gate that becomes very important under U.S. patent law, right? In terms of establishing when something came into creation that a company has created, right? And once they come here to the United States, they can take advantage of that first date that they've established either internationally or in their home country in order to kind of start the clock here.
Absolutely. That's exactly right. It's called a priority date. And I'm dealing actually with this issue right now for one of my medical device clients. You have to assume that the competitors are looking at what you're doing competitively, and they're going to be looking at you entering the US, and they're going to look at their own patents. And they're going to try to figure out, do I have a patent with a date, priority date, a date that I first filed something with the appropriate authority, either in the US or overseas, that predates this person's commercial entry into the US. And so from that perspective, yeah, absolutely vital to think about that and make sure that to the extent that you have overseas protection with an earlier date that you can plug into and benefit from, that you make sure that that information gets passed along to lawyers and is incorporated into your US filings.
Right. So since your example focused on the technology company, right, let's kind of dive a little deeper into that. What is, if we can get a quick overview as to what is patentable in the United States in terms of software, for example? Can you patent software? What are some of the nuances around that particular patentability?
Yeah, I'm going to give you a short answer, then I'm going to give you a more complicated answer. The short answer is yes, you can absolutely patent software. You can patent databases. The longer answer is for at least the last decade, at least the last 10 years in the US, there's very much a cycle and a push and pull between the exact scope of that. So, but let me give you a few rules of thumb. If you just have a business method that you implement on a computer, so let's say I come up with a new currency trading scheme, or, and I just want to go, hey, I have this great currency trading scheme. I'm going to put that on a computer. It's going to be subject to a lot of scrutiny. You may not be able to get a patent on it. Ultimately, the test, and it gets very complicated, but at a high level, the test is your invention, and you need to have an invention, does it improve the operation of something technological? Does it improve the functioning of the computer? So examples of things that have gotten patent protection that's been approved at the highest level of the US courts. So the highest level of the US courts that deal with these issues have said, this is a patentable invention. Is, for instance, a new way of organizing a database. As opposed to tables, you have a particular field in a particular column that works. That's an example. Software and algorithms very specific to digitizing faces, or translating some kind of image into a different way of pixelating it. You need to, a lot of people have this conception that I had this great idea, I've invented something. You actually need really a step beyond that, an actual detailed implementation of that idea that you can describe in the patent and claim. Those are the rules of thumbs around software. But if it's just a business method, if it's just an ordinary way of doing business that you've now put on a computer, it's going to be, it's unlikely that's going to be patented.
Right. So United States has a pretty robust intellectual property system that's been around and been developed over the last centuries, right? Ukraine, on the other hand, has a fairly new intellectual property system that's literally being changed almost every year, including last year, when a particularly new government agency was established to handle patent applications, trademark applications internally within Ukraine, similar to the USPTO office. That organization is not even in existence yet, right? So internally in Ukraine, it's going to be changing and evolving. In the United States, we have a pretty robust process that's already in place. So I think it's easier for us to follow that process that's been in place for a couple of centuries at this point, and it's very foreign, for lack of a better word, for companies coming into the United States that are used to completely different regulatory schemes in their own home countries. So, and that's the purpose behind these conversations, right? To educate, provide an overview of various business considerations. So. We've talked about patents, which is, we can spend hours talking, days talking about patents. I mean, for God's sake, you taught a class at law school on trade secrets and other intellectual property. So I'm sure we can dive deeper into that, but I want to kind of shift the conversation a little more from patents to other intellectual property considerations that a company should be considering if they're entering the US market. So give me some of those, what are those categories? And then we'll unpack each one a little bit deeper.
Yeah, I think the next logical move, if we're staying with this IT telecom software example, is trade secret, and then we'll go to copyright, and then maybe with trademark. And the reason I say trade secret is it's probably the biggest contrast to a patent. And anybody that is looking to file a patent needs to make a fundamental choice between whether they're going to take whatever is their competitive advantage idea and protect it as a patent versus keep it secret as a trade secret. So trade secret is, like the name implies, something that you keep out of the public domain, that you keep within the walls of your company, that you put the appropriate fence around, often through contracts with your employees in terms of non-disclosure and confidentiality agreements, often through technological barriers, like we all know you can put certain folders and have them password protected or put them on a separate server. So fundamentally, a lot of the more sophisticated clients that have standardized IP transactional units and departments within their company will have committees that decide. They'll have an inventor come in and they'll say, well, we came up with this new algorithm, and they'll decide, do we want to get the benefit of patent protection, or do we want to keep this as a trade secret? And here's the calculus. On the patent side of things, the reason a patent is so powerful is it gives you exclusivity once it issues. So once the US Patent Office says you have a patent and it's granted, and you get that piece of paper with the official ribbon, you now have roughly 20 years of exclusivity. And it doesn't matter if somebody else comes along and is using that algorithm and they got it completely on their own, they didn't even know about you, you still can keep them off the market. It's that powerful. The problem is, after that 20 years, everything that you've put in that patent is public and accessible to anyone and free to use. Now, in the software space, IT space, that's a little less important, just because the nature of the market is things change every couple of years. In the life sciences, medical device, pharma space, much more important, because that is actually the biggest engine for your market exclusivity, along with some regulations in the US that I'm not going to get into.
Right.
On the trade secret side, however, the nice thing about it is your competitors can't monitor your applications, right? If you file a patent application, 18 months in,
it's out there.
Out there. And you can keep all of that special know-how, that special sauce, locked up. Coca-Cola is the big example in the US. Their formula for Coke has been secret forever. Now, but what that is, the reason it's a big contrast to the patent system is there's really no federal agency or state agency involved. That's just you. That's just you and your business operations. And your mechanism for enforcing that is if somebody happens to take your trade secrets. And it's usually an employee that goes to leave to a competitor and sticks in a flash drive and downloads some documents. You can now go to the court system in the US and get protection by bringing a case for trade secret. It's called misappropriation, but it's essentially trade secret theft.
Right. So trade secrets, as you mentioned, and you said the word, it's the secret sauce that makes your company special, or your products or your services special. And you want to keep that confidential. You want to keep it from being released out there, because a patent describes in detail what you're doing, how you're doing it, and why you're doing it, right? So everyone sees that once the patent issues, right? While they can't take that idea and run with it, they can extrapolate, and sometimes they can be successful at it, and sometimes not. That's part of the patent litigation that you're often involved in, I'm sure. But a trade secret is very different. It's something that's private to you, private to your company. So you mentioned that the consideration, whether or not to pursue a patent, the discussion internally, or whether to keep something as a trade secret, is very much dependent on what industry you're in, what kind of company you are, what your business plans are, what your business model is, because patent is not necessarily the target here. It's really supporting the business model and using the intellectual property to support and further your business goals, right?
Yes, absolutely.
Yeah.
Absolutely.
Okay, so patents, Trade secrets, complete opposites. No federal enforcement or no federal protection really for trade secrets. It's actually more of a state level type of a protection that's offered to companies. What else is out there that the companies should think about or know as they're entering the U.S. market for their intellectual property protections?
Yeah, I mean, I think the other two categories, and frankly, from a heart of research and development, I think your patents and trade secrets are the big ones. The things to also keep in mind are copyright and trademark. Let me do actually trade. I said I was going to do copyright first. Let me do trademark now, because we can deal with that very easily. Trademark is protecting your brand, right? So that's if you have a distinctive name either for your company or for your product. It's it's the McDonald's name is protected as a brand. That's what we're talk Coca-Cola protected as a brand, to return to that example. That's what we're talking about when we're talking about trademarks. Typically, you also file typically with the federal government. You can file state by state, but frankly, from a cost perspective, it's just much for roughly the same amount of money. Filing at the federal level it makes the most sense. You need to be using that brand in actual operations. And then you file for a trademark registration. It's subject to a lot less scrutiny than a patent is. And so a patent, you're thinking about ultimately, on average, a 3-year process before it issues. Trademark, 3 years.
That's 3 years, yeah, okay. 3
years, on average. Sometimes longer, sometimes shorter, but sometimes longer, 3 years. Trademark, you're talking about within a year. And that's probably, I'm giving you, again, rough estimates. And you would get your trademark protection. And then, of course, once you have that, and even a little bit before you have that, if you need to go to the courts, and you will typically go to the federal court, then you can enforce those trademark rights. Copyright is also a pretty lightweight acquisition, like obtaining regime. It's a registration. You file with a separate U.S. organization called the Copyright Office. The thing to remember about trademarks, you think about literary work, you think about a book, right? Or you think about a photo or an artwork. That's kind of the regime of copyright. The reason it matters in the industries that I deal with, particularly in the software industry, is decades ago, US courts have said your software program, the code that you write, is protected just like a book would be protected.
Like a work of art.
It's a literary work of art.
Literally a work of art. You're writing, you're putting words on a computer screen or words on paper.
Absolutely. Right. And you're fixing it in tangible medium, you're fixing it in paper, and it's protected. And so if somebody has access to that code and copies it, then they are liable for copyright infringement. And that notion that code is protected as a copyrighted work is really the primary engine behind all of the software licenses that everybody, I'm sure, is familiar with and has seen a lot. I'm getting a license, I'm getting permission to use this copyrighted software. Again, it's not like a patent in that it's a much more lightweight, easy to use system. And frankly, some clients of mine, once they get educated on how to register, they can register pretty easily with the Copyright Office, and it's a $50 fee, $50 fee, roughly. There's some wrinkles to it. You have to submit a copy of your code and redact out certain things. Delete them, only certain pages, because you don't want your trade secrets to leak. All of the records in the Copyright Office are accessible to the public. But that the copyright regime is of particular weight, heft, importance to the software industry in particular for their operating.
Right. Okay. So you mentioned copyrights. You mentioned trade secrets. So you have some layering of IP protections that a company has to consider. Again, whatever works for their business model, right? It's not the same answer for everyone. It just depends where they're coming from, what they're doing, and how they're doing it. And they have to consider all these things. And the best way to do it, I just want to make sure we get that out there again, is to have a conversation with an expert, somebody like yourself, right? Before they come in, before they really dive into the business of doing business, because that's what most entrepreneurs want to do. They just want to get to doing business. They don't want to deal with the details at this point right now first, but it's very important that the companies consider that, especially in the technology space, because of so much competition out there, because of so much attention that's being paid to intellectual property issues by companies who are already established here, right? Anytime a newcomer comes in, everyone's hyper-focused of what are they doing, how are they doing it, are they violating something that's already out there in order to protect that competition and protect their space, right? So after a company comes here, right, after they establish business operations in the United States, let's say they haven't thought about intellectual property protection until then. They're already here, they're already contracting with clients, they're already contracting with vendors, and they're already doing their business, right? Anything particularly negative about that, or do you really recommend that they talk and think about these things prior to coming in, or once they come in and establish operations, they can still rely on these protections on the federal and state level?
Yeah, wonderful question. I think the conversation should be had before you come in if you are focused on patents in particular. That's the one regime, the patent regime, where the consequences of doing something overseas could really impact your ability to get patent protection in the US. If you're in the US and you start protecting your trade secrets here, you start protecting your copyrights here, trademarks here, I mean, you get some level of protection under the law automatically. You get more powerful protection if you file the registration system. Patents, however, you have essentially, and I'm oversimplifying, you have essentially a 1-year window from the time that you put your product out there to file for patent protection. And
that's what I wanted to get to. Yeah, that's what I want to get to, because I think that's a very important point for companies coming in that are unaware of the US patent scheme in terms of regulatory requirements. So let's talk about that a little more, what that 1 year is, how it's being looked at, and why that's very important.
Okay, so under the US patent statute, Patent Act, if once you put something out there into the public, and that means just start selling, and it can be in the US or it can be overseas. It can be overseas. Once that happens, the clock starts running. And if you don't file for patent protection within that 1-year window, if you later file for a patent, and even if that patent by mistake ultimately gets issued by the patent office, if you ever try to enforce it, your activities that predate the patent's filing date by more than a year will invalidate the patent. That means the patent goes away. It's unenforceable.
Okay, so the practical question, and I'm sorry to interrupt you, but the practical question is, if a company has been operating and established in Ukraine, they've been working on a specific technology for a number of years, they've already put that technology out there or a product out there 2 years ago in Ukraine, just in Ukraine.
Mm-hmm.
2 years later, they decide, we've had some success here locally, we want to enter the US market, obviously for obvious reasons, size. So they come here, but they've already been operating this technology. It's already been out there for 2+ years. Where do they stand?
They're in a world of hurt unless, so my strategy at that point would be to get with all of the creative people and figure out, do you have a version 2.0 of the product that you're going to go to market with? Or do you have an add-on, a feature add-on that you think is going to be a primary attractor or driver of your sales in the US? And let's just patent that improvement. Let's just patent that add-on. There are ways of, there's a ways of slicing what you claim as your invention. But fundamentally, if you are selling your bicycle in the Ukraine for 2 years and you come in the US and you're like, I'll file for US patent protection on that very bicycle, it's never going to happen. It's never going to happen. Now, you can say I came up with a new wonderful set of brakes for the bicycle that I haven't sold yet, and then you file a patent for the brakes. That's the easiest example.
Right. Okay. So I know I interrupted you, but we have a few more minutes. Let's unpack that 1 year period a little more.
Mm-hmm. Sure. Anything in particular you want to?
Any kind of nuances that you want to share? I mean, is there any other nuance about the 1 year period, or we kind of cover the basics of it at this point?
No, I think that's basically it. I mean, what I would say is, if you have this issue, the first thing you do, talk to a patent lawyer, ask them about the 102 issue. That's the magic language, 102. And then there's a very particular set of laws and regulations around 102 that will go through it. But other than that, 102 is the section of the US patent law that deals with this 1 year window that defines it. So again, if you're seeking legal counsel, tell them I've been selling overseas in the Ukraine for a couple of years. I may have a 102 issue. That's your magic language to get this analysis done.
Okay. All right. So we have a few minutes left. I want to make sure, and I think you covered, well, you didn't cover, but you mentioned that there are costs and fees associated, right, with filing for patent or other intellectual property protections. I've obviously been familiar with them and I've reviewed them. And I reminded myself yesterday as I was doing some homework in preparation for this call as to those fees can get pretty hefty, right? You have the initial application fees, you have review fees, and then you have not annual, but like periodic fees that you have to pay to the U.S. Patent Office, to the U.S. government to maintain the patent that you filed for and earlier received, but you have to maintain it for the course of the 20 years. So is that something you're aware of the top of your head? Because I wrote some numbers down and I want to throw them out here just to make sure that people are aware as to how much funding this may take in terms of getting a patent in place and then maintaining it for the following 20 years.
I'm happy to go with the numbers that you have. The thing I would add first is you have to think about it as two components. One is the fees. That's what you pay to the agency. And then one is your attorney's fees, right? So if typically if somebody comes to my firm and asks for, we call it a prep and pros, filing a patent application, that means preparation and prosecution. Prosecution is the magic language for that negotiation I was referring to between the patent office and yourself. I mean, that runs, the budget for that typically is about $10,000 for the attorney fee perspective. Now if it's a really important invention and you need real care with it, it could run you more. If you just want something quick and dirty, it likely will run you less. That's to the law firm. And then I forget the exact number of fees. It's in the thousands of dollars, but you file one fee at the time that you file the application. And then each subsequent event, each subsequent part of that negotiation back and forth usually is associated with an additional fee. And if you want to run through some numbers, I'm happy to get the latest and greatest. I always look it up because it constantly changes.
Right. So as of yesterday, the U.S. patent filing fee is $320, which is not a big deal for utility patents. The search fee is $700, and if you engage in some of this negotiation with the agent of the U.S. Patent Office, the reviewer of your application, that it can run you $700, $1,200, kind of escalating every time there's some sort of an issue that they have to research. The examination fee is $800. And then that's where the numbers kind of surprised me because it's been a little while since I looked at them. The issue fee is $1,200, but at 3.5 years after the issue, it's a $2,000 fee. 7.5 years after, it's $3,760 fee. And then 11.5 years after, there's an additional $7,700 fee. So yeah, again, for a company like SAP, it may not be a big deal unless they have thousands and thousands of patents. Obviously, then it becomes a larger financial consideration. But for a young company coming in, a startup that we often see, a technology startup coming out of Ukraine or other country, these should be taken into consideration because that's obviously an investment of time and an investment of money towards these IP protections, which could be very important for the business models, right? Yeah. So it is what it is. Go ahead.
Yeah, I was just going to say, the idea behind those later fees is it gives you a chance and windows to review and figure out, is this patent important or is it not, right? So if you file a patent, get it, 3 years later, you're on version 4.0 of your software and the technology has moved so fast that this patent's outdated. You may do one of two things. You may just not pay that fee and abandon it. You may sell that patent off. There's a marketplace in the US for patents because other companies may want to have it and bring a lawsuit over it. So there's you can think of them as windows to review your IP strategy that arise periodically.
Excellent. That's a great way to look at it. And Alex, we are at the 30-minute mark, and as true to the name of the podcast, Quick and Dirty 30, we want to stay within the 30-minute conversation. So thank you for joining me. It really has been a pleasure to talk to you. I know we've covered some high-level overview. Obviously, there's a lot of detail and nuances in what you do on a daily basis for companies. I, again, would like to encourage anyone listening to this, if you're considering entering the U.S. market, talk to an expert. Earlier, the better. It'll benefit you. It'll benefit your company.
Well, it's been my pleasure, and I echo that. And good luck to anyone trying to make it into the U.S. If you can make it here, you can make it anywhere.
Absolutely. Alex, thanks a lot again.
Thank you, Alex.